Yes, please. This is how a decree is prepared. After this is how the deduction is made. Just have a look at it. आप इनके साथ ना थोड़ा बैठ के इनको बनाएं. चलिए.
Password is item 3. The LPC 5781 of 2016 along with item 4 to 6.
We have concluded.
Yes.
Only last one judgment, 2 pages, cite and then we have challenged MPG guideline. Primarily, one of the ground is that because it is also covered under LPG order, and therefore it is a criminal.
That is only ground.
The consequences are, Your Lordship, one judgment of 2023, Supreme Court, Your Lordship may see para 8, only 3 lines are written. Second line, we should not go into these aspects, that is a matter to be considered and examined in the investigation. A wrong may be civil wrong or in a given case civil wrong and equally constitute a crime. So here also, even if it is covered, some portion of it, even if it is covered by a criminal LPG order, then also the same set of facts, a civil wrong also can be there.
And as per your chart, everything is not covered.
No, very few of them are.
There is some overlap.
Some overlapping is there, but
You
in
give it to them.
that the consequences are punishment in the shape of imprisonment in LPG order, whereas in our case it is only a penalty. What is covered is in the one page, two pages. And Your Lordship, according to me, this RM service decided by Honorable Supreme Court also substantially covers this issue, which I have also placed on the last.
That is why the Honorable Supreme Court has said that for the purposes of enforcing disciplinary guideline, the search and seizure need not be in terms of the criminal case.
Yes, absolutely.
And
That
CRPC as such is not happening.
yes.
Because that was a point.
Yes. And
Whether the search and seizure has to be in terms of CRPC.
Order, that order which was there in question, then Your Lordship would refer that the Honorable Court also relied, and it was there in the Honorable Court's order that it took note of guidelines and said that it was in terms of the contractual obligation of the
Yes,
party.
that we have marked down.
Yes. That is.
The judgment just handed over, that is 2023 SEC Online Supreme Court 1610. In this short span of time which I was gathered from this judgment, that this is an established principle by the Honorable Supreme Court in several cases, that an action may have a civil wrong as well as a criminal wrong. It is well certain that an act of a person may involve both the liabilities. It can be a civil liability, it can be a criminal liability, it can be both civil and criminal. In some cases, the Honorable Supreme Court has held that if it is predominantly a civil wrong, then it should not be allowed to be given a color of criminal prosecution. But the conduct at various points of time has both the colors of civil wrong and a criminal. So to that extent, this 2023 SSC Online 1610, this is on a completely different aspect altogether. Here, the case of the petitioners are that the civil liability which the respondents are intending to contend throughout their submissions and reply furnished by them, that is being sought to be connected to faithful performance clause, whereas we are trying to impress upon the Honorable Court that when there is a central enactment and a delegated legislation or a subordinate legislation wherefrom the term marketing discipline guidelines has been coined, whether the genesis of marketing discipline guidelines will be traced to the central enactment or it will be traced to their contention in the counter affidavit with reference to faithful performance. In my humble submission, if the law, validly enacted law, gives the genesis of the guidelines, then it has to be traced to that extent, and then it has to be seen as to when the central enactment or the delegated legislation, that is the Essential Commodities Act 1955 and the LPG Orders 2000, to what extent it has been delegated in the provisions as to what will be the ambit and umbrella of marketing discipline guidelines which they can do. Because what the legislature could not do, the executive could definitely not. So if the legislature could not prescribe such a procedure akin to marketing discipline guidelines and had to adhere to the Essential Commodities Act provisions of 1955 for ensuring fair play, transparency and observation of natural justice, and then the violations which are there in the LPG Order 2000, they have taken care of the devices which may come in the distribution or marketing of liquefied petroleum gas. The executive cannot have the authority which the legislature did not have. Other contention from the written submissions which has been submitted by the respondent, it transpires that they are raising the objection with respect to the arbitration clause in the Act. Section 8 of the Arbitration Act takes care of this aspect. It says that a judicial authority power to refer parties to arbitration where there is an arbitration agreement, section 8. A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement shall, if the party to the arbitration agreement or any person claiming through or under him so applies not later than the date of submitting his first statement on the substance of the dispute, then notwithstanding any judgment, decree or order of the Supreme Court or any court, refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. So, the catchwords as per my humble understanding, is that the subject matter of the action which is brought in a matter which is the subject matter of the agreement. So, the list between the parties before the judicial authority has to be identical and same and similar, which is covered by the arbitration agreement or the arbitration clause. If there are something more than that, then under section 8, in my humble understanding, the judicial authority cannot bifurcate the claims and decide part of it and refer the rest of it
What
for
is
the
something
arbitration.
more?
I'm sorry, madam?
What is that something more which is not covered by the arbitration?
That
That is the legality of marketing discipline
marketing
guidelines.
discipline guidelines and the entire challenge to the punishment order is inherently and intrinsically.
No, you see, there are two parts. The whole purpose of entertaining this petition and deciding it is that you have challenged the validity of a particular provision.
A particular deed or document.
Whatever,
Under the
it is
challenge.
not just a document, it is much more than that.
It's a
It is
guideline from the.
Yes, right. And then certainly the arbitrator, the arbitrator will not have the jurisdiction to decide whether that particular document is as per the provision of law.
Constitutional provisions.
So that is why that aspect has come. But so far as you suppose we hold that it is unconstitutional, then everything goes, all your allegation goes, all your punishment goes, whatever it is, everything goes. But if we hold that it is valid, then under such circumstances, do you want to say that even if certain allegations require evidence, even if certain allegations are required to be proved, then also this writ court will decide those allegations. We have seen numerous orders. You see, in taxation, the provision of law is challenged directly in the High Court, right? And ultimately, when those provisions are upheld, so far as the show cause notice and the adjudication is concerned, that is left to the authorities to be done. So similarly, if we, in case we find that it is valid in the eyes of law, then all the necessary adjudication will be done as per law. We do not know, and you will have your remedies. You may challenge that, whatever it is, you may challenge it before the arbitrator,
Yeah.
and then you will have your option to invoke arbitration.
The objection of arbitration is being raised by the respondent.
Yes, and that issue is still open.
And
There is a specific order to that effect, that this alternative remedy issue is still open.
by section 8 subsection 2, the Act says that the application referred to in subsection 1 shall not be entertained unless it is accompanied by the original arbitration agreement or a duly certified copy thereof.
You see, we are not going to refer it for arbitration. There are two different things altogether. One is when the court is referring to arbitration. They have not filed any petition under section 8. So there is no scope of referring it for any arbitration. We will say, at best we can say that there is an arbitration clause, but the petition will not be entertained. And then you will have your remedy, you come under section 11 or whatever for appointment of arbitrator. These two are two different things altogether.
Now, my lord, if suppose, my lord, presuming that if the writ petitions are not, my lord, allowed on the ground of challenge to the MDG, now, my lord, we are in litigation since 2011, 12, 13, 14.
Section 14 will apply.
So, but then that will also be, my lord, a bit of difficulty for the parties to overcome the hurdle of limitation. Then, my lord, my submission is that if at all the situation which has been just, my lord, given by the Honorable Court, that in tax matters, the virus of one or other section is challenged along with the assessment order or the so-called notice, and then if the virus of the section is held to the board, then the matter is remitted back to the authority concerned to act in the light of the provisions of rest of the sections. My lord, that is a central enactment. Here, my lord, the basic dispute and the basic issue being raised by the petitioners that this MDG guidelines, marketing discipline guidelines, is not at all a statute.
That we will decide. We are not asking you to go to the arbitrator for a decision on that. That we will decide over here. There is no problem.
And the chart which has been handed over to me just now, my lord, what I could come to understand from their presentation, that by virtue of this, it is being tried to impress upon the Honorable Court that more or less the issues which are covered under the marketing discipline guidelines differs from the LPG order. Lord, that difference,
They say that there are overlaps,
there are overlaps,
but they are not identical.
but not to the greater extent, to maybe to a lesser extent. Lord, that can be appreciated by the Honorable Court if my lords will go through the number of illegalities or irregularities which have been defined in the marketing discipline guidelines. in one way or other, the violations which are there
You
in
see,
the
we
LPG,
will only decide the wider issue. We will not enter into this.
For
we
deciding-
will only decide the wider issue. We will assume that even if there is a violation which falls under Essential Commodities Act, and if the same violation falls under this order also, this guideline also, what is the consequence?
well,
This is the broader issue we have to decide. We are not going to enter into this kind of a comparison. Whether it is, we will just say that they say that there is overlap, but at the same time there are differences. And you say that all the violations are contemplated in the LPG order itself. There cannot be any other
And
violation outside that.
and the differences, whatever they are being trying to impress, they are actually sub-classifying the violations of the LPG order 2000. There is a case of sub-classification by refining it into one clause, then second clause, third clause. Broadly, everything is covered under the LPG. Now, on the factual part, my lord, may kindly come to the writ petition WPC 5781 of 2016. My lord, the so-called notice is annexed to page 51.
This, I think you are in rejoinder now.
Yes. And
Yeah,
I had
but-
not submitted on the factual part.
I don't know if you have not submitted, that's your problem.
My
You
lords, on
cannot
the
have a second round like this.
my lords,
You are on rejoinder, I suppose.
on the first date after the relisting of the matter, my lords had observed that we will first hear on the legal issues and then we will look into the factual parts because some of the aspects were not, my lord, touched in the first round of hearing. And
You have
therefore,
given your written submissions.
that is, my lord,
You have, after the conclusion of the arguments on the last day, you have given your detailed written submissions, isn't
de-
it?
detail is more or less only on the legal aspect. Factual aspect, I have just touched certain annexes, but I need to indicate, my lord, what is the malafide and whether that
Who's malafide?
malafide of the respondents.
Which respondent?
The respondent Indian.
Which respondent? The entire organization cannot act in a malicious manner.
My lord,
Which respondent is that?
that is the senior area manager Ranchi.
No, he is not named. He is not party by name. We can't decide his malafides.
My lord, he is not party by name, but
We
this
will not decide his malafides who is not a party before us in his individual capacity. When you allege malice,
no, I am not alleging malice.
then what?
I am alleging malafides. Malafides, my lord, will be reflected from the document itself. What the SOPA says and how they have
You see,
proceeded.
I'm making it very, very clear to you. I'm not going to enter into this. This essentially requires evidence. This requires adjudication, full-fledged adjudication.
My lord, may come to a conclusion of what has come from my lord, may come to a conclusion. My lord, after seeing what I am trying to indicate, my lord, may kindly appreciate
You
what
say I'm making it very clear. If I uphold the provision, if I say that this marketing discipline guideline is ultra vires, then everything would go because they are acting under the marketing discipline guidelines only. And then, so far as these aspects are concerned, we will not enter.
my lord, if there is a violation of natural justice and
That is
malafide,
not-
which is
what-
reflected from the records of the writ petition
Even
itself.
in case of natural justice, you just tell us the arbitrator has no business to enter into natural justice. Can he decide it? He cannot
My lord,
decide the legality of marketing discipline.
My lord, natural justice is a fundamental right. And
Why
if
did
there
you
is
enter into arbitration clause?
if there is a,
There should not have been any arbitration clause. You should have objected to it at the threshold.
I would have been ousted from the dealership distribution.
You did not challenge it.
I'm sorry, my lord.
You did not challenge the arbitration
No, there are-
clause. That is not
My
under
lord,
challenge.
there are dotted lines, typed
Yes,
persons.
these are
which
essential commodities. All these things are dotted lines.
Which the distributors are under compulsion to
It
sign.
is not
if
your
they
case. It is not your case that beholds this arbitration clause, you are compelled to sign it, and therefore it is not binding on you. That is not your case.
My lord, but Article 14, if it is being violated, if it is arbitrary and violation of natural justice.
You cannot force a read court under 226 that merely because there is some violation
My
of
lord,
natural
the question
justice.
of forcing does not arise. I am only saying, my lord, that Article 226 and even 32 is maintainable if there is a violation of fundamental right. And that is what I am trying to indicate.
The
to
court
the
would
Honorable
never say Constitutional Court would never say that any petition is not maintainable ex specialis. It is for the court to exercise their jurisdiction subject to their conscience and what they think about a particular case, whether they want to exercise their jurisdiction or they do not want to exercise their jurisdiction. The little which I have read from the records is that it cannot be a straitjacket formula, nor it can be decided in writ jurisdiction. It would require evidence.
I am trying to indicate something which, if I am permitted to place before the Honorable Court, probably the Honorable Court will be in a better position to appreciate what I am trying to indicate from the show cause and one of the supplementary affidavit on record, which they have not denied.
We do not know. You have taken leave of the court to file supplementary affidavit.
Well, supplementary affidavits are being filed in our court, it's a matter of practice, and they are accepted.
Anything which you bring on record which was within your knowledge at the time when you file the petition, you should take a leave. We will not call upon every affidavit to be answered by them. That is not the manner in which a deputation.
They are in receipt of these affidavits for past 2
Maybe,
years.
maybe.
They have not responded to it. Maybe the Honorable Court will not call upon them. But my lord, if I have brought it on record, if it appeals to the Honorable Court, my lord may take consideration of it. My lord may refuse if it doesn't appeal.
You see, I am making it very, very clear to you. I don't want to enter into your individual disputes. We are on the broader aspect of the matter, whether this is in accordance with law. There is no point entering into these individual disputes.
But देख लीजिए हम क्या indicate कर रहे हैं. Maybe my lord will appreciate what is there. For a moment, it will hardly take 2 minutes.
क्या दिखाना चाहते हैं? रीड रिकॉर्ड से दिखाएं.
Read record annexure 2. Is this so cause?
पेज नंबर
51. This has reference to a joint inspection carried out by sale officer LPG Devghar and manager LPGS Bokaro on 27/5/2016 at your distributorship. During the inspection, a customer contact with randomly selected customers of your distributors was also carried out by the inspecting official. During the inspections, customer contacts following shortcomings, irregularities have been detected. Number they have referred to an inspection report of 27/5/16. This is in the supplementary affidavit dated 16/1/23. It is intrinsically connected to this so cause, and it will throw light whether the charges which have been made there are supported from this inspection
We
report
will
or
not
not.
enter into that. Please don't ask us. We will not enter into the intricacies of the inspection report, then tally it with these allegations. We are not going to enter into that exercise. That exercise is not within our jurisdiction.
Arbitration clause itself says all questions.
I'm very
Disputes.
conscious of this. I'm very conscious of this arbitration clause. Had this clause would not have been there, I would have seen it. On the face of the arbitration clause, I will not look into this.
But if that is what is coming from the arbitration clause of the agreement, may kindly see.
And whether a dispute is covered under arbitration clause or not, that by itself a subject matter of jurisdiction before the arbitrator.
That is subject matter.
So you cannot now at this stage argue that this is not covered by the arbitration.
No, that is not the case. What I'm able to assess that since the Honorable Court is not inclined into getting into the factual aspects, if the writ petition is finally decided in favor of the petitioners, then there may be a further litigation if the factual aspects are not dealt with in the order passed by the Honorable Court.
That is your prerogative to litigate.
No, I'm saying otherwise. If the Honorable Read Court finally decides that the maintainability aspect is in favor of the petitioners, then, my lord, I think, my lord, reference may also be made to the factual aspects also, which are being, my lord, challenged before this Honorable Court.
See, maintainability issue is still open. That is not closed. So therefore, this court is making it very clear that maintainability issue will be in two parts. One is with regard to challenge of the disciplinary guidelines, and other is challenge to the show cause and the consequences thereafter. This is in two parts. Then under such circumstances, you can just imagine how many assessment orders would have been subject matter of scrutiny to the High Courts and the Supreme Court directly, without following the statutory remedies under the Act.
Lord, what is referable under the Arbitration Act may I just indicate.
Yes.
That is page 48 of the writ petition. All questions, disputes and differences arising under or in relation to this agreement shall be referred to the sole arbitration of the director marketing of the corporation. If such director marketing is unable or unwilling to act as sole arbitrator, the matter shall be referred to sole arbitration of some other officer of the corporation by such director marketing in his place, who is willing to act as such sole arbitrator. It is known to the parties hearing that the arbitrator appointed hereunder is an employee of the corporation and may be shareholder of the corporation. The arbitrator to whom the matter is originally referred, whether the director marketing or officer as the case may be, on his being transferred or vacation his office or being unable to act or for any reason, the director shall designate any other person to act as arbitrator in accordance with the terms of the agreement, and such person shall be entitled to proceed with the reference from the stage at which it was left by his predecessor. It is also the term of this agreement that no person other than director marketing or the person designated by the director marketing as aforesaid shall act as arbitrator. The award of the arbitrators so appointed shall be final, conclusive and binding on all the parties to the agreement and provisions of the Arbitration and Conciliation Act 1996 or any statutory modification or reenactment thereof, and the rules made thereunder for the time being in force and applied to the arbitration proceedings under this clause. So, all questions, disputes and differences arising under or in relation to the agreement. Now, it is a specific case, that the disputes arising out of the agreement. Marketing discipline guidelines is a completely different document deal altogether. A guideline which at best from the nomenclature itself can be dealt to be a guideline. My submission is, that any dispute arising under the guidelines is ousted from the clause of this agreement.
This also has to be agitated before the arbitrator.
And what is the stage when a dispute is to be referred? My lord, I give a hypothetical situation that I claim something and my learned friend denies it. Lord, if I accept it, there is no dispute. If I don't accept it, then I raise a dispute. Lord, if I raise a dispute, it is for me to go for the arbitration. Lord, here is a case, my lord, they claim. I give a denial, my lord, submission in my response. They don't accept it. So they are creating a dispute. Now it is up to them to refer it to the arbitration.
Whosoever
And having
Yes.
not done so, I had referred to a judgment of the Honorable Supreme Court in my written submission. I will place 2-3 paragraphs from that. The one who does company limited. that is 2014, 10 SCC 673. But the issue before the Honorable Supreme Court in this case was that there was a guideline issued by the central government with respect to protection of environment. And under the guidelines, the civil constructions within the range of 500 meters from the sea coast were directed to be demolished. This action was challenged by the affected parties, in which they lost in the writ court. They also lost in the division bench. Matter went up to the Honorable Supreme Court, and the Honorable Supreme Court said that it cannot be enforced as it does not comply with the provisions to be treated as an enforceable law of the land, and for reasons which are there not in the paragraphs. The Honorable 14 by 10, 6, 7. Para 15, if my Lord may kindly come to. The question, what is law, has perplexed many a jurisprudence. Yet the search for the elusive definition continues. It may be unwise to posit an answer to the question, rather one may proceed by examining the points of consensus in jurisprudential theories. What appears to be common to all these theories is the notion that law must possess a certain form, contain a clear mandate, explicit command, which may be prescriptive, permissive, or penal, and the law must also seek to achieve a clearly identifiable purpose, while the form itself or absence thereof will not be determinative, and its impact has to be considered as a lending or supporting force. The disclosure of a clear mandate and purpose is indispensable. It may therefore be understood that a government policy may acquire the force of law if it conforms to certain form possessed by other laws in force and encapsulates a mandate and discloses a specific purpose. It is for the aforesaid prescription that the guidelines relied upon by the Union of India in this case will have to be examined to determine whether the same satisfies the minimum elements of law. The said guidelines are so and so, so and so. Then, my Lord, may kindly come. Paragraph 19. Article 77 of the Constitution provides the form in which the executive must take and authenticate its orders and decisions. Clause 1 of Article 77 provides that all executive action of the government must be expressed to be taken in the name of the President. The celebrated author H.M. Sirvai in Constitutional Law of India, 4th edition, volume 2, 1999, describes the consequences of government orders or instructions not being in accordance with Clause 1 or 2 of Article 77, by opining that the same would deprive the orders of immunity conferred by the aforesaid clauses, and they may be open to challenge on the ground that they have not been made by or under the authority of the President, in which case the burden would be on the government to show that they were in fact so made. In the present case, the burden has not been discharged in any manner whatsoever. The decision in Air India Cabin Crew Association versus Yashaswini Merchant, taking a somewhat different view, can perhaps be explained by the fact that in the said case, improved directions contained in the government letter, not expressed in the name of President, was in exercise of statutory power under Section 34 of Air Corporations Act 1953. In the present case, the improved guidelines have not been issued under any existing statute. Para 21. In absence of due authentication and promulgation of guidelines, the contents thereof cannot be treated as an order of the government and would really represent an expression of opinion. Para 22. May I read further para 21? In the said guidelines and their binding effect would be no more than what was expressed by this court in state of Uttaranchal versus Sunil Kumar Vyas in the following paragraph of the report. It is settled that all executive actions of the Government of India and the Government of State are required to be taken in the name of President or Governor, or the state concerned as the case may be. Article 77(1) and 166(1). Orders and other instruments made and executed in the name of President or Governor of a state as the case may be, are required to be authenticated in the manner specified in the rules made by the President or the Governor, as the case may be. Article 77(2) and 166(2). In other words, unless an order is expressed in the name of the President or the Governor and is authenticated in the manner prescribed by the rules, the same cannot be treated as an order on behalf of the government. Then note para 22. It is also essential that what is claimed to be a law must be notified or made public in order to bind the citizen. In Harla versus State of Rajasthan, while dealing with the virus of Jaipur Opium Act, which was enacted by a resolution passed by Council of Ministers, though never published in the Gazette, this court had observed. Natural justice requires that before a law can become operative, it must be promulgated or published. It must be broadcast in some recognizable way so that all men may know what it is, or the very least, there must be some special rule or regulation or customary channel by or through which such knowledge can be acquired with the exercise of due and reasonable diligence. The thought that a decision reached in the secret recess of a chamber to which the public have no access and to which even their accredited representatives have no access, and of which they can normally know nothing, can nevertheless affect their lives, liberty and property by the mere passing of a resolution without anything more, is abhorrent to civilized man. Now, at the bottom of the last three lines, there must therefore be promulgation and publication in their cases. The mode of publication can vary. What is good method in one country may not be necessarily the best in another, but reasonable publication of some sort must be there. It will not be necessary, para 24, to notice the long line of decisions reiterating the aforesaid view. So far as the mode of publication is concerned, it has been consistently held by this court that such mode must be prescribed by the statute. In the event the statute does not contain any prescription, and even under subordinate legislation there is silence in the matter, the legislation will take effect only when it is published through the customarily recognized official channel, namely Official Gazette. If the guidelines relied upon by Union of India in the present case fail to satisfy the essential and vital parameters of the requirements of law, as the trend of the above discussion would go to show, the same cannot be enforced to the prejudice of the appellant as has been done in the present case. A distinguishing factor with respect to this judgment and the case in hand is that the contention of the respondents that the guidelines are being sought to be connected to the faithful performance clause of the agreement. But my lord, that I would be repeating my submission, but that attempt, even though my lord contended before various high courts of this country, and the honorable courts have proceeded on those contentions to give a judgment and finding upon the validity of the upon the enforceability of the marketing discipline guidelines. But the issue which is being raised before my lord with respect to tracing the genesis to the Essential Commodities Act and the LPG order, lord, that were never before the other honorable courts, and therefore this aspect of the case has never been considered by any of the high court of this country. And if my lord will kindly see, save and accept the marketing discipline guidelines which is part of this writ petition, the other marketing discipline guidelines, the forward my lord may kindly see in the next writ petition, the 3952 of 2011, what the marketing discipline guideline opens with the opening terms.
See, when it comes to marketing discipline guideline, you have said that all these matters are identical. That is why they are there. We are referring to only one marketing discipline guideline. Now you want to say that different guidelines are different.
Guidelines have changed their form and content with passage of time. The 2001 marketing discipline guidelines speaks of that MDG 2001 for LPG as approved by Government of India. And 2015 they say something else. So they cannot have a fluctuating stand, my lord. When in 2001 they
See, therefore, when you tag the matters, you should be careful about it. That different marketing guidelines has to be considered differently. Now you want that I will scrutinize all the writ petitions,
no,
and then say that this guideline is different from the other.
it's not on that issue that whether this is different from the other. I am highlighting these aspects only to submit before the honorable court that their contention is not supported by their own stand, that it is an outcome of the faithful performance clause. They chose that contention in the 2015 guidelines. They keep on fluctuating their stand. In 2001, they say it is approved by the government of India. They never refer to the faithful performance clause. 2015, they became wiser and then they start referring to that clause. So, if they are not certain about from where they are deriving it, and if there is a genesis of central enactment leading to that marketing discipline guidelines where there is a particular prescription upon which it has to be framed, and if they have crossed that prescription or transgressed their jurisdiction, then the aspect which is beyond the authority delegated under the LPG Order 2000, that is unauthorized and it cannot be enforced in law, apart from the other legal points which I have taken, that it is not enforceable in law for the reasons this. Therefore, I was indicating because in all the cases, marketing discipline guidelines is under challenge. But their contention has to be looked into from their own documents as to how.
I will not read one marketing discipline guideline into another. Can I read that? I will not read that. This is your document, you have annexed it, you have challenged it.
It is their
I will read this document as it is. Now you want me to read another marketing discipline guideline and then derive something out of it. How is it possible?
In order to test the validity,
no, we will not. This is not the manner in which the validity is to be tested. This is not the manner in which validity is to be tested. I will see the document as it is, as it has been placed, and then you just look at it. You are re-arguing the entire matter. Why are you re-arguing the entire matter? Facts you said that you did not place. Okay, now you are coming up with this. The different marketing guidelines are different. Your entire contour of argument is changing.
If I am to,
you can't shift your arguments like this. You have been given sufficient opportunity to argue so far as the marketing discipline guideline is concerned. You cannot deny that.
I am still addressing on the same aspect.
No, why do you need? For rejoinder, you don't need to re-argue your matter.
I am responding to their contention that it is being derived from the faithful performance clause. If I am trying to indicate the contradiction in their submission. Their contradiction, if it is reflected from two documents which are their documents, although brought on record by me. My lords are not inclined to enter into those arenas. I'm sorry, I will then conclude my submissions. But I was only assisting the Honorable Court on the aspect whether their contention can be held good in law or not.
Different cases are for different period.
3 of them fall under 2001 guideline and the first one falls under 2015 guideline.
इस तरह से ना कभी कोई केस कभी कंक्लूड ही नहीं होता. It will never get concluded. Every time you start off with new fresh points, आपको प्लेस करना चाहिए था ना. गाइडलाइन दोनों का अलग अलग है तो अलग अलग प्लेस करना चाहिए था गाइडलाइन. At the threshold you should have placed it. That these are two different guidelines. The source is not the same. The texture is not the same. The contours are not the same. The source of power is not the same. You did not place it. हम तो पहली बार वो वाला गाइडलाइन देख रहे हैं. ना पहले आपने वो प्लेस किया था, ना आपने अपने पिटिशनर के आर्गुमेंट के समय उसको प्लेस किया. तो पहली बार वो वाला रिकॉर्ड देख रहे हैं. For the first time, you never placed that there is any distinction between the two. The two are totally different. That was not your case. You never argued it. Also,
as indicated in 2001 guideline, there is no provision of appeal. In 2015, they come with the provision of appeal.
इसके अलावा क्या ही फर्क था?
Page 73 of the writ petition is
Writ petition में आप बहुत चीजें बोलेंगे, ऐसा नहीं.
Writ petition 3952 of 2011.
5-2.
3952 of 2011.
गाइडलाइन में अपील किस में है?
I'm sorry,
गाइडलाइन में अपील
15
किस में?
2015 में अपील है. That appeal is also restricted in sense that certain irregularities are not appealable against the penalty order, certain are appealable.
सेकेंड रिकॉर्ड में आपका डिसिप्लिनरी गाइडलाइन किधर है? मार्केटिंग डिसिप्लिन गाइडलाइन
73 with an excess 7.
थ्री 3952
3952.
पेज नंबर 73.
Page number 73. Annexure 7. It may be after the typed copies. Ten 5 2001 document.
क्या है? इट ओनली कंटेन्स अ चार्ट. इसके अलावा कुछ नहीं. Is this a complete document?
That is what has been published to me, and we have brought it on record. They have not disputed or neither brought any other document to say that it is not the marketing list.
And on top of this, here Respondent number 8 has been made party by name. The notice has not been served, and you did not take care to ensure that the notice is served before the matter is ultimately taken up. The office note reveals that notice has not been served. Right? So, what is the consequence and who is responsible for this?
That he is a party by name because there were certain personal allegations.
So
against him.
therefore, he is the only one who can refute it. None else. You have not taken care that the notice stands served upon him. At no point of time you indicated ये सारा ये record तो place ही नहीं हो रहा है. Place हो रहा है वो record जिसमें कोई party by name नहीं है ना? पहली बार हम लोग इस record को खोल के देख रहे हैं. Where he is a party by name. The office note says that the notice has not been served upon him. Respondent number 2 to 7 is only appearing before this court. ये टैग करके ये सारा केस फाइनल डिस्पोजल होके आज हम लोग 15 दिन से इसको सुन रहे हैं और पहले भी सुन चुके हैं. He is not there before us.
So to the extent of personal allegations against him, that cannot be agitated by the petitioners.
Certainly. And that is an integral part of your challenge to the show cause notices. Marketing discipline guideline. बस इतना ही है ये 3 पेज का चार्ट.
इतना ही चार्ट है लेकिन यूनिवर्सिटी में सी द थर्ड पेज. Main contents are already there. Established major irregularities and then what is the penal action for that. And then the next page contains the minor irregularities. And the third page, then it says that
No
other
provision for
clauses are-
appeal is proposed.
Yes. And in the new one, that
Since
is
existing provision under the agreement are sufficient.
because arbitration clause was
Arbitration
there.
clause is there.
In all the cases, the arbitration clause is there. In all the cases. So this is the only difference. In all the other 3 cases, the 2001, it says that no provision of appeal. But in 2015, the first one which my learned friend was raising, there is 2015, there is a provision of appeal also, and the original agreement also contains an arbitration clause.
Under the provisions of Essential Commodities Act, what is the consequence of a violation?
Imprisonment and fine,
Termination
termination.
is not there. Termination is guided by this guideline. What is the
Termination-
consequence when it will be terminated? What will be the consequences? How much fine is to be imposed? And this is also followed by termination.
Termination is already there in the agreement.
Maybe it is there, but this guideline is making specific references for the various instances where it has to be followed by, it is in stages. First stage, this much of fine will be imposed. Second stage, this much of fine will be imposed. And third stage, it is termination. Your Essential Commodities Act does not talk about termination at all.
But they have, even then they under the agreement they have the power.
So
to
do you want to say that since the Essential Commodities Act does not provide for termination, there can be no termination?
No, there is already a clause of termination in the agreement itself.
So therefore,
They are only
agreement,
classifying the.
therefore, whatever provisions have been made in the agreement, be it termination, be it first fine, second fine, whatever, is something which is specific to the agreement and the guidelines. And these kind of punishments, if not in the nature of penal law, this kind of punishments under the civil law is contemplated under the agreement and guided by the guidelines. Suppose there is one violation and it's just first violation. The dealer will have a matter of right to say कि आप terminate नहीं कर सकते because of this guideline. Because this guideline will bind them. First violation you cannot terminate because first violation में the consequence has been provided. Second violation होगा, then also you cannot terminate because the consequences has been clearly provided under the guideline. It is only under the third stage, third violation, that there is a question of termination. So they cannot even terminate it on account of violation. As per the agreement, they will not be able to terminate it because of this guideline.
whatever will be the holistic, altruistic and benevolent nature of the marketing discipline guidelines in connection to the public at large or in relation to the parties per se, unless the said guidelines are supported by any authority to be issued, their benevolence and altruistic character will have no force of nothing to have an interplay among the relationship between the parties. And this termination clause, they being there without any clause of fine in the agreement, fine aspect is already taken care of under the Essential Commodities Act. In the garb of being altruistic and benevolent, their contention is that they are taking unto themselves to impose punishments. My lords have seen that
In all the cases, show cause notices have been issued and has been taken to a logical end. In all the cases, there is an order of termination.
And in none of the cases they had asked for personal hearing. The Honorable Supreme Court has very clearly said that personal hearing is not required unless, so service of show cause notice and the reply was absolutely sufficient compliance of the principle of transparency.
Yes, we have seen here this marketing discipline guideline. In the rest, in all the cases, it's the same.
Same guideline.
Where you say that the matter was referred to Government of India for approval.
Look, it says opening page 70,
73.
73. We are enclosing the revised MDG 2001 for LPG as approved by the Government of India.
That's
If it is approved by the Government of India, then I will be relying upon the Garbon case, the principles laid down by the Honorable Supreme Court. And this, my lords have seen, and my lords have also seen the marketing discipline guidelines of 2016. It is being argued just now that in the third page there is a line that no appeal is provided because the situation has been taken care of in the agreement. From there it is attempted to be connected to the arbitration clause. But I say, unless it is specifically referred to, that attempt may not be maintainable in the eyes of law, because arbitration clause, if it is to be adhered and to be referred to in the marketing discipline guidelines, they have done so in specific terms in the 2015 guidelines, but they have not done in the 2001 guidelines, because in 2015 they related to the one of the clauses of faithful performance. So there has been a shifting stance. If it is one time as approved by the Government of India, the other time it cannot be under the faithful performance or contract. And this power of introducing marketing discipline guidelines through a particular clause, that is actually having unto themselves the power to amend the contract as and when it suits them and introduce any condition which can be imposed by them without any option to the distributors to object to it, and they are bound to comply.
so. You want to say anything more?
Only one line. Time and again, Your Lordship, we have referred to this faithful performance clause.
It is there in all the agreements?
Yes, all the agreement, and Your Lordship, once they agree, enter into an agreement, sign the agreement, take benefit of the contract, and benefit part they take. And when it says that the distributor undertakes faithfully and promptly to carry out, observe and perform all directions and orders or rules made from time to time by the corporation or its for proper carrying of the distributorship of them. So once they sign it, then they are aware of the whatever rules are being framed, they are bound by it. Absolutely, it becomes part of the original contract itself. And in all the agreement, there is an arbitration.
Heard the learned counsel's appearing on behalf of the parties. this repetition, the petitions have been filed for the following relief. हर एक का relief quote करना है. The learned counsel for the petitioner has submitted that these cases have been tagged as because the marketing discipline guideline framed by Indian Oil Corporation, framed by the respondents, is under challenge, and the only distinguishing feature is that in WPC number 5781 of 2016, the marketing discipline guideline under challenge is of the year 2015, and in rest of the cases, the connected marketing discipline guideline is of the year 2001. However, he submits that the validity of marketing discipline guideline, be it 2001 or 2015, is essentially on the ground that the same is without jurisdiction in as much as the marketing discipline guideline is divorced of the provisions of Essential Commodities Act 1955 and the Liquid Petroleum Gas within bracket Regulation of Supply and Distribution bracket close Order 2000. And these guidelines are not referable to any source of power. Correct? The learned counsel has also submitted that so far as the marketing discipline guideline of 2001 is concerned, the same reveals that it was circulated after approval of the Government of India, which is apparent from Annexure 1, by which the same was circulated by its letter dated 10/5/2001 to all the Indian distributors of Indian Oil Corporation. He submits that once the marketing discipline guideline is approved by the Government of India, then it has to be referable to some source of power ingrained in the statute which governs the distribution of LPG, that is the Essential Commodities Act or the order framed thereunder, or the Constitution of India. And such marketing discipline guidelines cannot be framed and since the marketing discipline guideline is not referable to the Essential Commodities Act and the order framed thereunder, the guidelines are wholly without jurisdiction. He has relied upon the judgment passed by Honorable Supreme Court reported in bracket 2014 bracket 10 SEC 673 paragraph 15
called out in another court.
You can go, but don't file a review petition.
Understand, ma'am?
Don't file a review petition. I will not entertain that. If you want to go to another court, you can go, but please do not file a review petition. Paragraph 15 thereof, to submit that, the paragraph 15, 16, 19 and 21 thereof, to submit that the executive action has to be undertaken in terms of the provisions of the Constitution of India, and such marketing discipline guidelines do not have the force of law, and therefore any action taken under the marketing discipline guideline as involved in all these cases are also without jurisdiction. The Learned Council has submitted that apart from the aforesaid, the Learned Council has submitted that if the marketing discipline guideline, which is under challenge in all these writ petitions, is set aside, then all the proceedings which have been undertaken thereunder leading to termination of leadership of the petitioners before this court would also not survive. The Learned Council has further submitted that the show cause notices which has been issued to the petitioners were malicious, motivated, and not specific, and the responses which were submitted by individual petitioners to the show cause notices were also not appropriately appreciated and dealt with all fairness and transparency. It has also been stated that the respondent all of them are Indian Oil Corporation. The respondent, Indian Oil Corporation, has not led any documentary or oral evidence in support of the allegations made in the show cause notices. The Learned Council has submitted that there has been violation of principles of natural justice and the petitioners have not been treated fairly by the respondent oil company. Therefore, the writ petition is otherwise also maintainable irrespective of the alternative remedy of arbitration provided under the agreement entered into between the parties. The Learned Council has also submitted that so far as marketing discipline guideline is concerned, there is no specific arbitration clause mentioned there. the Learned Council has placed the provisions of Essential Commodities Act and has referred to Section 3 and Section 6 thereof, and has referred to Section 3, which deals with power to control production, supply, distribution, etc. of essential commodities, and has submitted that the said section deals with all the circumstances relating to maintaining increasing supplies of any commercial commodity or essential commodity, or securing equitable distribution at fair price, and regulating and prohibiting the and takes care of all the relevant aspects for the purposes of dealing with essential commodities. And it also has the provision for delegation of power, and has the power for confiscation, he has in particular referred that the violation of the provisions of Essential Commodities Act deals with imposition of penalty by way of fine, and there is also provision for imprisonment, etc. The Learned Council has also referred to the Liquefied Petroleum Gas Regulation of Supply and Distribution Order 2000, which has been framed under Section 3 of Essential Commodities Act, and has submitted that the Schedule Roman 7 framed thereunder the Schedule Roman 7 under clause 11 within bracket 4 framed thereunder, in particular clause 6 thereof provides for marketing discipline and guidelines proposed to be adopted. He submits that marketing discipline guideline is contemplated under the provisions of Essential Commodities Act, read with the Liquefied Petroleum Gas Regulation of Supply and Distribution Order 2000, and therefore the marketing discipline guideline, which has been framed by the respondents and have been imposed upon the petitioners, is not sustainable in the eyes of law. the Learned Council has submitted that the marketing discipline guideline lacks legislative competence and authority and is not enforceable. And the guidelines of 2001 does not even contain any provision of appeal, whereas the guidelines of 2015 provides for an appeal only in exceptional cases, in case of termination of leadership or distributorship. He has further submitted that in 2001 guideline there is no requirement for the oil companies to furnish documents in support of the charges made in the show cause notice. And there is no procedure for any personal hearing to the affected party before imposition of penalty in the nature of fine, which is expropriatory and confiscatory in nature. And such fine is recovered from the oil company from the security deposit or advance deposits made by the dealers like the petitioners. The Learned Council has also submitted that. The respondents have sought to justify the marketing discipline guideline by referring to the faithful performance clause, but such reference is not permissible in the eyes of law, as the respondents are not competent to impose penalties which are essentially quasi-criminal in the form of fine. He has further submitted that the breach of any agreement may result in civil consequences in the form of damages, recovery of loss, compensation, etc. But so far as imposition of penalty is concerned, the same is in the nature of fine and has roots in section 53 of Indian Penal Code, being one of the punishments for the offences committed therein. And therefore, the respondents do not have any jurisdiction to impose fine. To impose penalty in the nature of fine, a reliance has been placed to the judgment passed by the Honorable Supreme Court reported in 1965 SCC Online SC 18. And has submitted that it has been held in the said judgment that criminal proceeding ordinarily concludes by imposition of sentence, and fine or forfeiture of property is also prescribed sentence under the criminal jurisprudence. But so far as civil proceedings are concerned, the same is followed by payment of debt, damages, compensation, and delivery of specific property. He has further referred to the judgment passed by the Honorable Supreme Court reported in bracket 1975 bracket close 2 SCC 22 to submit that it has been held that imposition of pecuniary liability is comparable to a punishment for commission of an offence. And in the instant case, penalty is in the nature of fine, which has been created by the respondents themselves through MDD marketing discipline guideline, and the same is not backed by any enactment, and therefore the provision of penalty in the nature of fine in marketing discipline guideline is without jurisdiction. The Learned Council has referred to the provisions of Essential Service Maintenance Act. Is this the same as Essential Commodities Act? That's different. आपने दिया था ना एक बार इसकी कॉपी, और एस्मा है आपके पास कॉपी एस्मा की? ये भी तो एसेंशियल कमोडिटीज है. He has referred only to Essential Commodities Act. ESMA Act का तो आपने कोई रेफरेंस नहीं किया.
He was time and again stating ESMA.
But he was referring Essential Commodities Act.
I wanted to point out at that time, but I missed it. That was Essential Commodities.
You are only referring to Essential Commodities Act. यहाँ पे ESMA लिखे है लेकिन आपने प्लेस नहीं किया है इसमें. Yes? You are not aware, your senior is aware. Correct? क्या लिखे हैं? क्या लिखे बताइए? कॉलिंग क्या? ही इज बिजी. अभी 4:30 बजे के पहले वो फ्री नहीं होने वाले. आर्गुमेंट करके कोर्ट छोड़ के जाना बहुत आसान है. जजमेंट भी सुन के जाना चाहिए ना. जितना पेशेंटली हम आर्गुमेंट सुनते हैं उतना पेशेंटली आप जजमेंट भी सुनिए. आपको रोकते नहीं है बहस करने से हम किसी को, लेकिन दिस इज नॉट प्रॉपर. अब बीच में कोर्ट छोड़ के चलेगा जब हम जजमेंट लिखा रहे हैं. तो अभी आपसे पूछ रहे हैं कि एस्मा का तो आपने रेफरेंस ही नहीं दिया, तो यू आर क्लूलेस, यू आर नॉट अवेयर. If you expect patience from a judge, we also expect patience from you to sit and listen to the judgment. Right? पिकनिक नहीं मना रहे ना यहाँ पर. बहस करने का पेशेंस है तो जजमेंट सुनने का भी पेशेंस होना चाहिए. I will say that you have not referred to ESMA Act. You have not referred to this act at all. Correct?
Yes.
They have not referred. हम इस एक्ट का कोई रेफरेंस हम इसमें नहीं देने वाले. रिट में भी नहीं है ना? नो रेफरेंस. He has submitted that under the provisions of Essential Commodities Act, there is a clear provision for imposition of fine or even sentence for violation, and the case is to be tried by a court of judicial magistrate. An LPT Control Order 2000 is a delegated legislation under Section 3 of the Essential Commodities Act. And the Control Order 2000 and the Essential Commodities Act taken together prescribes for actions which are permissible and which are not permissible both by the distributors and the companies dealing with petroleum products. By referring to the aforesaid judgment reported in bracket 2014 bracket close 10 SCC 673, the Learned Council has submitted that it has been clearly held that any executive action must conform to the prescription of Article 77 or Article 166 of the Constitution of India to have a force of law. And all executive action of the government, either at the union or the state level, are to be taken in the name of the President or the Governor, as the case may be, and is required to be published in the official gazette. he has further submitted that in absence of any publication in the official gazette, such guidelines are not enforceable. However, during the course of arguments, the Learned Counsel has fairly submitted that the point of publication of the requirement of publication of marketing discipline guideline has not been taken in the litigation or in any of the pleadings filed in this case. The Learned Counsel has further referred to the judgment reported in 1967 SCC Online SC 21 to submit that every executive action has to be supported by some legislative authority, and the Essential Commodities Act of 1955 read with the LPG order of 2000 clearly covers the field when a distributor can be punished with imposition of penalty in the nature of fine, and has laid down the procedure to be adopted for such infliction of punishment. However, the guidelines has given a complete go-by to the procedure which has been prescribed under the Essential Commodities Act of 1955 and the LPG order. He submits that the procedure prescribed under the guidelines cannot be sustained. No, he has submitted that what legislature could not do, even the executive cannot do. If the legislature could not impose a penalty of fine without adhering to the procedure contained in the Essential Commodities Act, the respondents also cannot impose the penalty of fine on the basis of marketing discipline guideline. The Learned Counsel has also referred to the judgment passed by the Honorable Supreme Court reported in bracket 1969 bracket close 2 SCC 262 to submit that all quasi-judicial inquiry must be held in good faith without bias, and what particular rules of natural justice should apply to a given case would depend to a great extent on the facts and circumstances of each case. The Learned Counsel has submitted that there is no legal framework to support the marketing discipline guideline, and the respondent oil company has usurped upon themselves the power and authority to carry out the exercise of imposition of punishment of fine. He submits that the fine, being punishment in criminal jurisprudence, could not be imposed under any civil dispute arising out of alleged violation of marketing discipline guideline and cannot be relatable to faithful performance clause of the contract. He has further referred to judgment passed by the Honorable Supreme Court reported in bracket 1981 bracket 1 SCC 664 to submit that prior hearing is better than the subsequent hearing, but subsequent hearing is better than no hearing at all. The Learned Counsel has also submitted that the judgment passed by the Honorable Supreme Court, which has been relied upon by the respondents, reported in bracket 2019, bracket close 19 SCC 662, is not applicable to the facts of the present case in as much as in the paragraph 15 of the said judgment, the parties to the litigation before the Honorable Supreme Court never disputed that they are governed by marketing discipline guidelines as applicable upon them. The counsel submits that the respondents cannot be permitted to run a parallel governance in the garb of marketing discipline guideline, and they cannot be permitted to usurp upon themselves the power of imposition of punishment in the nature of fine, falling under the criminal jurisprudence without authority of law and legislative competence, and in absence of any clear and unambiguous statutory declaration to that effect. The respondents cannot be permitted to impose quasi-criminal penalty of fine by way of expropriatory, confiscatory exaction from the security deposit and advances. The Learned Counsel has reiterated that the alternative remedy of arbitration is not applicable to marketing discipline guideline, as the marketing discipline guideline by itself does not contain any arbitration clause. The arbitration clause is there in the agreement between the parties. The Learned Counsel has also submitted that the law is well settled that the action may have both civil and criminal wrong, but the fine being the penalty being in the nature of fine is criminal in nature, and therefore the respondents did not have any jurisdiction to impose fine, and such fine is only covered by the provisions of Essential Commodities Act and the order framed there. That's all. कुछ चुका आपका? ये चुका ना?
He pointed out that it was a typographical.
Typographical error, Your Worship. The ESMA Act was not ESMA, it was Commodities Act, Essential Commodities Act. There was a typographical error.
एस्मा तो बहस में बोलते थे एस्मा, लेकिन प्लेस नहीं की है. प्लेस तो एसेंशियल कमोडिटीज एक्ट ही करते हैं. The Learned Counsel, appearing on behalf of the respondents while opposing the prayer, has submitted that the marketing discipline guidelines has root to the faithful performance clause which has been provided in the agreement itself. They have further submitted that the dispute arises essentially out of contract between the oil companies and the petitioner, and therefore for framing and applying marketing discipline guideline, there is no need for any statutory backing. It is arising out of faithful performance clause, and some uniformity is maintained through marketing discipline guideline, which is applicable to all the distributors of LPG, which is an essential commodity.
And the petitioners have signed, knowing that they are bound to follow this.
The Learned Counsel has also submitted that the petitioners have signed the agreement between the parties with open eyes,
Conscious of the fact that there is
conscious of the fact that there is a faithful performance clause in the agreement, and the marketing discipline guideline of 2015 has specifically referred to the faithful performance clause and the obligations of the respective parties. He has referred to the introduction to the marketing discipline guideline as annexed in the writ petition being WP number
578. of 2016.
5781
5781
of 2016. The Learned Council has further submitted that merely because the marketing discipline guideline of 2001 was ultimately approved by Government of India, the same does not mean that it is beyond the contractual liabilities of the parties arising out of them.
Yes, because government also can enter into.
He has submitted that there is no legal power in government entering into the contract, and the contractual liabilities are not governed by the provisions of Article 77, 162 and 166 of the Constitution of India, and therefore neither any plea has been raised in connection with the publication of the marketing discipline guideline, nor there is any such requirement.
And there is no pleading with regard to publication in their bill.
Yes. He has submitted that there is no pleading of the petitioner in connection with the requirement of any publication, nor the petitioner has raised any objection in connection with the Article 71, 162 or 166 of the Constitution of India. ऐसा तो कोई provision का कोई reference नहीं है पूरे read में. I have not seen.
So publication is definitely not there.
नहीं, Article 171,
I'll
162, 163 का कोई
We
reference
just
नहीं.
rechecked, we did not find anything, but we just.
हाँ, you just in the meantime you check it because I could not get it when I was going through
And your
the.
lordship had given 2 pages of short note.
हाँ, I will refer. The Learned Council has also submitted that the while passing that the point of alternative remedy has been kept open to be considered. There is a specific order to that effect. आपको नहीं पता होगा. Order number.
Because initially it was being done by
Point of
service deviation.
Alternative remedy has been specifically kept open by it. By order dated 18/1/2023, wherein it has been observed that it is made clear that the point of alternative remedy is kept open. The Learned Council submits that so far as the legality of marketing discipline guideline is concerned, the same may not have alternative remedy, but if this court finds that the marketing discipline guideline does not call for any interference and is otherwise valid in the eyes of law, then under such circumstances, so far as individual cases are concerned, where there are show cause notices on the basis of allegations, response by each of the parties followed by final order, they can still avail the remedy under the provisions of, in accordance with the arbitration clause which has been provided under the agreement. The Learned Council has submitted that so far as the marketing discipline guideline is concerned, the same may not have a separate arbitration clause as the relationship between the parties is essentially guided by the agreement entered into between the parties, and the petitioners are distributed by virtue of the agreement and not by virtue of the marketing discipline guideline. The Learned Council has submitted that so far as the marketing discipline guideline of 2001 is concerned, the same does not have a remedy of appeal, and the marketing discipline guideline of 2015 has a remedy of appeal. But the agreement essentially has the remedy through the arbitration
in all the cases.
in all the cases. The Learned Council has placed the faithful performance clause of the agreement and has
First page your achievement scheme.
Yes.
The main argument starts from overlapping of
yes.
LPG order and
The
LD.
Learned Council has further submitted that so far as the argument of the petitioner that the LPG order as well as the MDT guidelines, they cover the same field, is concerned, there is overlap between the two is concerned, he has submitted that the violation of LPG order is visited with imprisonment, whereas the purpose of MDT guideline is to provide for monetary consequences to regulate and discipline the distributors so that the LPG consumers ultimately get the quality service. And the purpose of MDT guidelines you get page 6 of the supplement.
It is there, your Lordship, we have referred to the
First
purpose
page, na?
for
Yes.
bringing that
Yes.
guideline.
Has referred to the MDT guidelines, which gives the purpose of it, whereas the purpose of LPG order is contained in section 3 of the Essential Commodities Act. The Learned Council has thereafter referred to section 3 of the Essential Commodities Act, and has submitted that the MGT guidelines and the order and the LPG order serve different purpose altogether.
Yes.
And the purpose of MGT guidelines has been enumerated as under. ये 3 के बाद जो first point है वहाँ से ले लें, यही है ना purpose आपका. Therefore, for ये MGT guidelines has been issued.
In section 3 I have quoted,
हाँ.
and that mentions section 3 of the Essential Commodities Act. Under this, the LPG order is issued. So this says the purpose is the central government is of the opinion that it is necessary or expedient to do so for maintaining or increasing the supply of
The
any-
Learned Council has submitted that on the face of section 3 of the Essential Commodities Act, under which the MDT guideline, under which the LPG order has been issued, it is meant for maintaining or increasing supplies of any essential commodities at fair price and for regulating or prohibiting the production, supply and distribution thereof and trade and commerce therein. The Learned Council submits that so far as the marketing discipline guidelines are concerned, the same are to ensure that the public at large are served properly and the distributors work within the four corners of law. The purpose of MDT guidelines is enumerated as under. इसको डाल दें point wise जो है 1 2 लास्ट का 1 2 3 4 5 6 7 8 9 ये जो आपने point wise लिखा है
हाँ,
इसको डाल देते हैं पूरा.
पूरा.
The Learned Council has relied upon the judgment passed by Honorable Supreme Court reported in (2019) bracket 2019 bracket close 19 SCC 662 Indian Oil Corporation versus RN Service Center, and has submitted that the judgment is to be read as a whole, and in the said judgment since the dealer was not being prosecuted for violation of Essential Commodities Act and was being proceeded on account of violation of the guidelines, the Honorable Supreme Court was of the view that the provisions of search and seizure as is applicable for the control order and Section 3 of the Essential Commodities Act, which and the provisions of Code of Criminal Procedure as applicable for search and seizure are not required to be followed. The Learned Council has submitted that the Honorable Supreme Court has kept the violation under the Marketing Discipline Guideline distinct and different from that of violation under the Essential Commodities Act and the order framed thereunder, where the strict procedure of search and seizure under Code of Criminal Procedure is required to be followed.
And in paragraph 15, the Honorable Court says the dealer has entered into
The Learned Council has also referred to paragraph 15 thereof and has submitted that it has been held that the dealer having entered into an agreement, it is it was not disputed that dealer was bound by the guidelines issued by public sector oil marketing companies. The Learned Council submits that the dealer having entered into an agreement is certainly bound by the guidelines in the matter of distribution and marketing of LPG gas cylinders, which is essential commodity. The Honorable Supreme Court, he has also referred to paragraph 16 to submit that some of the provisions of the guidelines have been considered, and it has been observed that the guidelines are to streamline the functioning of the oil companies, streamline the functioning, that is, oil companies should not arbitrarily or without any justification send the sample for testing at their sweet will.
And your Lordship,
Para 19.
there are 14 last 5 lines. Therefore, we find that the effect of issuance of control order is that the event of violation of such control order, any person who contravenes any order made under Section 3 of the Act, the control order, he is liable to be punished by the court.
The Learned Council has also referred to paragraph 14 of the aforesaid judgment to submit that the effect and consequence of the control order and the violation of the provisions of Essential Commodities Act has been duly considered, and the consequence is to have penal consequences leading to conviction. And in the said case, the dealer was not sought to be prosecuted. Not sought to be prosecuted for violation of no, the learned counsel has submitted that for the purposes of prosecuting for violation of guidelines, the Essential Commodities Act is not attracted. Okay?
Not prosecuting, Your Lordship.
For proceeding. Proceeding. The Essential Commodities Act is not attracted. The learned counsel has submitted that if the marketing discipline guidelines are upheld by this court, then under such circumstances, so far as the other issues are concerned, they may not be gone into as they involve disputed questions of facts, and arbitrator is the appropriate authority to deal with it. If the petitioner chooses to invoke the arbitration clause.
And in all the cases, principle of natural justice have been complied with by issuance of show cause, and only after their reply, what has
The learned counsel has also submitted that in all the cases, the principles of natural justice has been complied in as much as show cause notice was issued, the response was taken, and then the appropriate order was passed, considering the response furnished by the. That's all.
And there was no request for personal hearing, and therefore the
And
Honorable.
since there was no request for personal hearing, there was no personal hearing was granted.
This judgment also we had cited.
What, sir?
This is 2012, volume 11 SCC.
He has
It is
referred
in the
to judgment reported in bracket 2012.
Volume 11 SCC, page 257.
250.
It is already there in the compilation.
यही एक जजमेंट पैरा नंबर याद है
Para number 38.
पैरा 38 हो गया आपका आपके आर्गुमेंट में आपका रिजॉइंडर भी कवर कर दिया इनका जो भी चीज़ ये बोल रहे थे इस जजमेंट का डिस्टिंक्शन आई हैव ऑलरेडी कवर ठीक है एज द कोर्ट टाइम इज ओवर पोज दिस केस फॉर फर्दर डिक्टेशन वेडनेसडे टाइप होने में टाइम लगेगा और हो सकता है तब उस दिन हम फाइंडिंग लेकर लिया ठीक है देयर इज अ लाइकलीहुड दैट आई गेट द फाइंडिंग अलोंग विद आफ्टर योर आर्गुमेंट्स सीए भी नहीं करना चाहते इनका जो आर्गुमेंट है ना इनके रिटन सबमिशन में सारा आर्गुमेंट्स है तो आपको उसमें से मिल जाएगा
Wednesday means
छुट्टी है क्या
today is Tuesday. So tomorrow.
नॉट वेडनेसडे मतलब नॉट टुमारो
Next.
23rd.
हाँ ठीक ठीक.
नेक्स्ट वीक तब तक बन जाएगा
नहीं नहीं ठीक है.
कुछ इसीलिए उस दिन कुछ लिखाना होगा कंक्लूडिंग तो लिखा देंगे
ठीक ठीक है.
आज भी ऐसा ही किए थे वो एक मैटर में फर्स्ट अपील था तो कुछ घर में लिखा लेते हैं तो फिर ऑपरेटिव
ठीक है,
में
ठीक।
लिखा देंगे अब ऑर्डर्स वाले केसेस हैं चलिए बताइए क्या क्या है जो लोग करना चाहते हैं वो लोग आ जाएं we will just call one by one. Those who are not there, we will not pass any adverse order. It will go to the
And if your lordship purpose of MDG guideline is quoted from the MDG
I will
guideline
quote.
first page itself, that would.
I'll quote it. I remember it.
Orders item 11, 1st April 47 of 2015.
आप दिए थे ना इसका? ऐसा नहीं आया है वो detail ये चार्ट। अरे इसका वहाँ से लेके आए थे ना, लेके आए जल्दी से। ऐसा नहीं आया इसका। अच्छा, FA number 47 of 2015. Was this case on 11th of June, awaiting service report.
Item 12, 2nd April 315 of 2016.
Yes. Office note क्या है बताइए? What is the office note?
Office note has a square number 9 that.
Await हो चुका है.
Again, square number 9. Now we have also filed the rejoinder. We have given different date of this. A two date has come.
इसको तो जब एक ऑर्डर हो गया है, अबेट हो गया, तो आपको तो फिर फाइल ही करना पड़ेगा ना, सेटिंग असाइड अबेटमेंट.
No, he has survived no legal years.
Who has no legal years?
Square number 9.
So we do not know. You have to file appropriate petition that he has no legal years.
Yes, I can file.
अबेटमेंट एंड नो लीगल years में फर्क है ना, दोनों एक बात नहीं है. ये फाइल ही करेंगे, खाली ओरली बताएंगे. पार्टीशन सूट है. तब तो आपको कौन कौन बच्चा है आपको नोटिस के लिए? 1 and 2 अपीयर हो गए हैं. देखिए, एज पर ऑफिस नोट, रिस्पोंडेंट नंबर 1 and 2 हैज अपीयर्ड. Respondent number 4 to 8 has been validly served. Appeal has abated as against respondent number 9. Notice is validly served so far as respondent number 3 is concerned. In terms of order dated 16/7/24. ब्रदर्स से सर्विस नहीं मानेंगे हम. Notice upon respondent number 10 has been handed over to his brother. Since the matter arises out of partition suit, the appellant is directed to take fresh steps for service of notice upon respondent number 10, for which requisite under ordinary process be filed within a period of 15 days from today. एक आईए फाइल हुआ है.
Yes, Lordship. We have filed, Your Lordship, for
इसका क्या किया?
क्या किया कल निकला.
क्या क्या बोले?
जो बोले इन्हें से एक्टिविटी रिस्पॉन्स नंबर 9 है डाइड ऑन 25/11/2009.
25/11/2009. That is after the
that he had died on 5/1/2006.
5/1/2000.
He the parties of the plaintiff side. We are the parties.
इसका आपके पास क्या प्रूफ है और इनके पास क्या प्रूफ? What is the source of the information?
He has given one certificate issued by the
Gram Panchayat.
Gram Panchayat.
तो
Yes,
आप
given
क्या
the-
डेथ सर्टिफिकेट लगाए हैं? फिर क्या लगाए?
Only certificate by issued by the Gram Panchayat.
आपने इन्होंने लगाया है. आपने क्या लगाया है?
We have filed one affidavit by the
An affidavit means what? Who has given you this information?
affidavit by the nephew, who said my Mochi had died such and such date, and we are applying for the certificate.
शमशान घाट का सर्टिफिकेट होगा ना?
Certificate
लेके
कितने
आइए.
issue हुए? वो बोले डेट
सर्टिफिकेट शमशान घाट का कैसे नहीं होगा?
हमने अप्लाई
ऐसा होता
किया
है क्या?
मिला नहीं. यही दोनों लिखा है.
आपका काम है, इन्होंने तो एक वहाँ का सर्टिफिकेट लगाया है. Anyways, one IA number 13217 of 24 has been filed on behalf of the respondents, stating that the judgment is a nullity. The judgment and decree of partition appeal number 5 of 2009 is a nullity as it has been delivered against a dead person. Post on 18th. पहले सर्विस करिए. आप रेस्पोंडेंट नंबर किसका डेथ हुआ? रेस्पोंड नंबर 9. आप कौन है रेस्पोंड नंबर 9?
We are the purchaser of property.
अब परचेजर आप तो रिलेटिव नहीं है ना? आप रिलेटिव है रेस्पोंड नंबर 9 के, तो भी उनका डेथ सर्टिफिकेट आप प्रोड्यूस कर दीजिए.
एस भी है, एस को भी सप्लीमेंट्री एफिडेविट के अकॉर्डिंग मिले आप आईए में.
हाँ ले आइए, आप डेथ सर्टिफिकेट प्रोड्यूस करिए. यू आर द बेस्ट पर्सन टू डिस्क्लोज. डेट तो दिए ना 18 जून.
Item 13, second appeal 327 of 2016.
Yes.
Two of the respondents, one and
Respond number 1, 6 and 14 have expired.
6 is not dead. Although it was informed by the other side that
6 is not dead.
6 is dead.
ये तो एफिडेविट बोलना पड़ेगा ना, आपको ऐसे कैसे चलेगा?
हमने दे दिया है कि 1 मर रहा है और 14.
आपने दिया एफिडेविट में लिखा है कि 6 इज अलाइव.
6 है. हाँ, वो ओरली सबमिट किए थे कि 6 मर रहा है.
तो रिकॉर्ड में हम लोग लिखे हैं क्या इसमें?
1 and 14 का.
हाँ, 1 and 14 आते हैं.
6 इज नॉट डेड.
No.
लिखे हैं क्या?
हम तो जो स्टेटमेंट वाज मेड 1 and 14.
लगता है उस दिन आप 6 बोले थे, हो सकता है कि बाय स्लिप ऑफ टंग हो, लेकिन 6 आप बोले थे.
लिखिए सेकेंड अपील नंबर 327 of 2016. The learned counsel for the respondent has submitted that it was wrongly submitted on 4/3/2025 that respondent number 6 and 14 has expired. Rather, respondent number 1 and 14 has expired. Counsel for the appellant has also submitted that respondent number 1 and 14 has
14.
expired and 6 is alive. Considering the aforesaid submissions, the order dated, it is recorded that the respondent number 1 and 14 be treated as dead, as respondent number 6 is alive. Correct? आप बताइए.
But there is delay of 1 year or more than 1 year. I will file reply.
Notice. आपको reply file करना है.
Madam, there is delay of 1 year or more than 1 year.
आदमी में है मेरा.
ऐसे ना फिर लिखिए आइए नंबर.
आइए नंबर.
You are representing whom? Respondent number?
1 to 6.
The counsel for the respondent number 1 to 6.
1 is the deceased.
Sorry, वो तो अभी substitution ही नहीं
जी
हुआ.
हाँ.
आपने legal years का नाम दे दिया है?
आते
हम लोग दे दिए.
आपने फाइल किया है substitution? Your file substitution? कहाँ है बताइए आइए नंबर.
आइए नंबर 4228.
इसमें नोटिस हुआ है?
नोटिस हुआ था तभी लोग बोले हैं कि
ये आइए नंबर 4228 में नोटिस हुआ है यहाँ से?
नोटिस
नोटिस नहीं हुआ है. ये तो ऑलरेडी अपियर हो चुका है.
डिसीज्ड is one.
दिस इज हम लोग के लिए
Deceased respondent के जो भी legal years से आप उनकी तरफ से appear हो गए हैं?
When you undertaken notice may go to the district.
और कोई आइए है substitution?
एक दूसरा ये है 4229.
ये किसका है?
14 के लिए correspondent नंबर 14.
आइए नंबर 4229 of 25 and 4228 of 25 has been filed seeking substitution of respondent number 14 and respondent number 1 and 14. The name of legal heirs and 14 and 1 लिखिएगा उल्टा number पड़ा है. The name of legal heirs and successors have been mentioned in the interlocutory application. Let notice be issued on the proposed legal heirs and successors of respondent number 1 and 14 for which requisites be filed under ordinary process within a period of 15 days from today. Post this case on 18th June of 1870.
Item 14, second appeal 125 of 2017.
1224 में नोटिस किया है क्या? इसमें नोटिस गया है 1224 में?
नोटिस टू माय लॉर्डशिप
कहाँ है?
वैलिडिटी सर्व भी हो गया. यस सर.
One A received by Dr. Manglo, one B by wife.
वाइफ
क्या है ये? पार्टीशन सूट है क्या है? क्या सूट है ये? कोई कॉन्फ्लिक्ट ऑफ इंटरेस्ट है आप लोग का? आपको कुछ पता ही नहीं है.
टाइटल सूट है.
आपसे पूछ रहे हैं कि ये जो जिन्होंने नोटिस रिसीव किया उनके साथ कोई कॉन्फ्लिक्ट ऑफ इंटरेस्ट है?
नहीं, रेस्पोंडेंट नंबर 1 जो है तेज नारायण है, वो डाइड इसकी वाइफ और 2 बच्चे और 5 लड़की थी. ये नोटिस हुआ. नोटिस पर
ऐसे नंबर 125 of 2017, IA number 1224 of 2025. This petition has been filed for substitution of deceased respondent number 1 Tej Narayan Rai. As per the office note, the notice upon the proposed legal heirs and successors has been served through their close relation. Counsel for the respondent has no objection to the prayer for substitution. Considering their aforesaid submissions, the notice upon the notice upon the proposed legal heir and successors of respondent number 1 is accepted as valid, and IA number 1224 of 2025 is hereby allowed. Counsel for the appellant is directed to delete the name of respondent number 1 from the cause title and insert the name of the legal heirs and successors in cause title in red ink within a period of 1 week from today. 1 हो गया. Respondent number 2 to 5, 6 का क्या स्थिति है? है सब. Respondent number 2 to 5 and 7 to 11 have already appeared, and notice upon respondent number 6 has already been served, and thus the इनकी तरफ से तो कोई वकालतनामा नहीं फाइल हुआ है. proposed legal heirs. Post this case on 18th of June, awaiting appearance of the legal heirs and successors of deceased respondent number 1. थोड़ा एक मौका देते हैं हमको.
सब्स्टिट्यूट कर दिया.
सब्स्टिट्यूट तो कर लिया. वकालतनामा क्यों?
हाँ.
Who may enter their appearance by filing wakalatnama so that the case is ultimately decided on merits. In case they do not enter appearance, another date will be fixed for final hearing. रिकॉर्ड आ गया ना इसका? एडमिटेड है?
हाँ, yes.
हाँ ये disclose.
Item 15, first appeal 164 of 2018.
This one is from the batch cases of 2018, first appeals of Kadru village, which has been already been heard. In this case, there was some delay, and for continuation of delay, the IA has been filed, IA number 3824 of 2020.
कितना delay?
Actually, they were very less, but as per the technical calculation, it has come to 1687 days, my lord. Because already we have filed, but since the certified copy of the EP order has not been filed, that part has also been taken. So, by the continuation of the delay, a similarly situated case has been, the delay has been controlled.
क्या बोलना है आपको delay?
What's the police matter? Respondent number 2 is the central railway, who is the main contributor.
They are not here. इसमें delay नहीं है. IA कहाँ है
Actually,
आपका?
again,
Where is your IA for continuation of delay?
I filed a supplementary.
Supplementary affidavit से delay नहीं control हो सकता.
Already there was a limitation, I filed for continuation of delay minor limitation, but the dates were not explained. For that purpose, I filed a supplementary. That is flag A. Under flag A, that has been.
आज बोलो नहीं है, आज नहीं ऑर्डर करेंगे, कल करेंगे. पोस्ट में कल आ जाइए. रेलवेज नहीं है ना यहाँ पे.
हाँ, बिल्कुल डिस्ट्रिक्ट रेलवे.
कल हम लोग टेकअप करेंगे 4 बजे के साथ. ठीक है, आप रेलवेज की तरफ से कल आप आइएगा, कल 4 बजे हम टेकअप करेंगे. ऐसे उनके एब्सेंस में 5 बजे नहीं कर सकते. हाँ बताइए. किस केस में?
The time of arising, but I am mentioning one case.
मेंशनिंग अभी तो उठने का कहाँ टाइम हुआ? कॉल करिए.
Lordship, Lordship.
Item 16, second appeal 500 of 2018.
अभी उठने का टाइम नहीं हुआ.
Lordship, in this case, in the compliance of last order, we have filed an IA for substitution of the deceased respondent number 9 because it transferred from the process service report and one of the respondent and died. Prior to that, there were notices issued in another substitution application 1338 of 2025. And as far as that IA is concerned, respondents 1 to 8 have appeared. And as regards respondent 10 to 12 and 15 are concerned, fresh steps have to be taken in line with the process service report. As regards respondent number
Just a moment. You have filed for substitution of respondent number 9.
9, so notice has to go in that also to the proposed dates of the respondent.
You have filed your IA.
I filed an IA number 4234 of 2025.
You want to take fresh steps on whom?
10 to 12 and 15.
10, 11, 12, 15.
And 15.
That's all.
In IA number 1338 of 2025.
Why IA number?
One of the appellant had died, and since the appellant were to be substituted, so the ladyship was pleased to issue notice because there was a delay, 974 days. So the
First, we will issue notice to the proposed legal heirs of respondent number 9.
then the ladyship disappeared. Send notices because process service report has come as regards 10 to 12 and 15 is concerned, then they were not able to be served. Otherwise,
10 to 10, 11, 12, 15.
yes, they will not trace this. So I'll trace out the address and file rate.
SA number 500 of 2018. Counsel for the appellant prays for and is allowed 15 days time, 2 weeks time to take fresh steps for service of notice upon respondent number 10, 11, 12 and 15.
If possible, ladyship, 4 weeks.
4
because
weeks
they-
correct.
strangers
10,
was-
11, 12 and 15 at their present and current address.
Yes.
So far as deceased respondent number 9 is concerned, IA number
4234 of 2025.
4234 of 25 has been filed. The names and legal heirs of respondent number 9 has been mentioned in paragraph 6. that notice be issued to the proposed legal years and successors of respond number 9, for which requisites be filed under ordinary process within 4 weeks. Sub 4 week कर दे रहे हैं, सर. Close this case
And leadership as per the
on 2nd of July awaiting service report.
and the certain process servers report has been received also accepted by the brother. This is a title suit, so notices can be accepted as validly served in respect of those, like response 1 to 4 and 5 to 8, and thereafter
Respondent number 1 to 4, respondent number 1, 2, 3, 4, 5, 6, 7 and 8.
and 13
Respondent number 1 to 8 have been served either personally or
they have
through
appeared.
their,
Leadership, they have appeared.
they have appeared.
Yes, I'm speaking for 13 and 14 because
Respondent number 1 to 8 have already appeared.
13 and 14 only. I explain for
So
that.
far as respondent number 13 and 14
Yes.
are concerned, as per the report of process server, it has been received by their brothers.
This is a title suit.
Considering counsel for the appellant at the request of at the prayer of the counsel for the appellant, the notice upon respondent number 3 is accepted as valid. Okay?
13 and
13 and 14.
yes.
Respondent number 13 and 14.
13
Correct? Okay? That's all?
okay.
Item 17, second bill 52 of 2020.
As per the office note, it has been reported that the office had wrongly indicated in earlier office note dated 12/3/2025 with respect to service of notice upon respondent number 8. Consequently, by the order dated 18/3/25, notice upon respondent number 8 is accepted as valid. As per the office note, in fact, the respondent number 8 could not be found. Considering the office note, the order dated 18/3/25 is hereby modified, and paragraph 2 of the said order, and it be treated that respondent number 8 could not be served, and therefore यार बनते नहीं बनते. And with respect to respondent number 8, the paragraph 2 of the order dated 18/3/25 is modified as under. So far as notice upon respondent number 8 is concerned, he could not be found. Office is directed to carry out the necessary corrections in order dated 18/3/2025. आप respondent number 8 को serve करिए. At this counsel for the appellant prays for and is granted 4 weeks time to take fresh steps for service of notice upon respondent number 3, 7 and 8. RTS क्या होता है? RTS क्या मतलब है? RTS ये क्या मतलब होता है RTS का? Respondent number 8 के आगे RTS लिखा हुआ है. What is this RTS? कौन है ये? ऑफिस नोट भी लिखने नहीं आता. RTS शॉर्ट फॉर्म लिखेंगे.
Respondents.
I don't know. R.T.S. Fresh steps for service of notice upon respondent number 3, 7 and 8 at their present and correct address. for which requisites under ordinary process be filed within a period of 4 weeks from today. Post on 10th of July, awaiting service.
Item 18, second appeal 190 of 2020.
118 में छुट्टी की बात कर रहे हैं 18 जून नेक्स्ट
Item 19, second appeal 98 of 2021.
इसको भी 18
Item 20, second appeal 48 of 2023.
Applied for combination of notice has been served validly. This has been recorded on the last week's order as well.
So why is it listed for orders?
Because there's an eye for limitation measure. There's 88 days of delay.
They have appeared.
No emotion.
We'll pass order tomorrow. 5 बजे order नहीं कर सकते हैं absence case. Post tomorrow कर दीजिएगा.
Item 21, first appeal 116 of 2023.
In this case, in this appeal manner, the IA has been filed for substituting the legal substituting the legal years of the appellate number 1.
देखिए first appeal number 116 of 2023.
It is within time.
IA has been filed for substitution of respondent number 1,
No, the appellate number.
appellant number 1. Let notice be issued to the respondents in the interlocutory application as well as in the main appeal, for which requisites under ordinary process be filed within a period of 4 weeks from today, post on 9th of July, awaiting service. दोनों में कर दी.
Both process.
In the meantime, let the records be called for from the concerned.
Okay, admitted है.
Admitted.
Admitted.
नोटिस बिना किए अब नहीं करेंगे. आपका सब्स्टिट्यूशन भी नहीं अलाउ. तो अदर साइड अपीयर हो चुका है सर.
अदर साइड स्टेट है इसमें.
और कोई नहीं है.
नहीं स्टेट है. तो इसमें हम अंडरटेक करते हैं कि इसमें हम अलाउ करते हैं.
ओनली स्टेट है.
हाँ, क्यों स्टेट है इसमें.
इसको कल करिए. कल करिए. कल आपका सब्स्टिट्यूशन अलाउ. अगर उनको काउंटर फाइल करना हो तो अलग बात है. वकालतनामा आपका सब्स्टिट्यूटेड लीगल केस का वकालतनामा
हम
का
अंडरटेक करेंगे 3 सप्ताह के अंदर हम फाइल करेंगे.
नहीं, आप वकालतनामा फाइल करिए. साथ में लेकर आइए वकालत. ऐसे नहीं होगा.
Item
एक
22,
सेकेंड इसमें
हम इसको
सिंप्लिसिटर इसको जो है ना
इसको नेक्स्ट वीक में रखा जाएगा. इसको नेक्स्ट वीक में
वकालतनामा आ जाएगा आपके पास.
मंगवा देंगे.
इसको सिंप्लिसिटर नेक्स्ट वेडनेसडे को करेंगे. पोस्ट ऑन नेक्स्ट वेडनेसडे.
Item 22, first appeal 47 of 2024, along with item 23.
This matter relates to compensation against land acquisition. Notices were issued to private respondent number 1 to 10. Out of that, 1, 6 and 8 have died. The others have received either personally or through relatives. None of them.
बट रेस्पॉन्ड नंबर 1, 6 and 8 को तो स्टेप्स लेना पड़ेगा ना.
If other respondents appear and they may provide me details, provide us the details I can file later.
Are you appearing for any of the respondents?
Serial number 23.
In the next case.
Yes.
देखिए FA number 47 of 24. Respond number 1, 6 and 8 have expired. Respond number 2, 4, 5. Respond number 2, 3, 4, 5, 7, 9 and 10 have been served notice either personally or through their close relative Accordingly, the notice upon name is accepted as validly served.
For example,
When do you want? For respond number 1, 6 and 8, when do you want?
I was saying that will be given so that other private respondents may appear and they may provide me
अब appear नहीं करेंगे तो जबरदस्ती तो नहीं ले आएंगे ना उनको. You take steps accordingly.
Because respondent number 6 and 8, they are the brothers of respondent number 7.
If they are not appearing, how do we get hold of them? Right? Pose this case on 18th of June. Take appropriate steps. जाइए जाके पता करिए.
The next page. Respondent number 1 to 11 where the
Item 24, first appeal 114 of 2024.
23. 23?
23 से साथ में दोनों
23 का तो अलग है, हमने 22 का ऑर्डर लिखा है.
दोनों
अच्छा ये सीरियल नंबर 23 में लिखिए. 22 and 23 साथ में. Cousin, brother, nephew, brother.
Everyone has been served. They have received notices then personally also.
ये भी लैंड एक्विजिशन है.
Same.
The respondent number, counsel for the appellant submits that the respondents 1 to 11 have either been served personally or through their close relative. 1, 2, 3, 4, 5, 6, 7, 8. And accordingly, he submits that the notice be accepted as validly served. Considering the submissions, the notice is upon the respondent number 1 to 11 is accepted as valid. और भी कोई respondent है? आप किनकी तरफ से? You are there? You have entered appearance. You will file. Mr. नाम बताइए. Mr. Manish Kumar undertakes to file. Advocate undertakes to file वकालतनामा on behalf of respondent number 1 to 11. Record आ गया? अब delay.
278.
He submits that if so advised, reply to the interlocutory application seeking confirmation of delay will also be filed. Reply file करिए, oppose करना है. हाँ? क्या बोल रहे हैं?
Record
नहीं आया.
Report was that NCR has been kept in fiction.
Pose this case on 17 June. Okay, और कुछ बाकी है. 24.
Item 24, first appeal 114 of 2024.
FA number 114 of 24 with IA number 3867 of 2025. Let notice be issued to the respondents for which requisites under ordinary process be filed within a period of 4 weeks from today. In the main appeal as well as interlocutory. Let the records be called for from the concerned. Post on 9th of July, awaiting service. हाँ बोलो क्या बात है?
One case here in item number 27. The land was acquired in the year 1920.
तो आप अभी कितना बचा?
And the compensation is awarded by LA court is in the year 18. Till date I am not a single pipe paid to me. And
कौन है respondent आपके? State?
नहीं, CCL है.
देखिए CCL के वकील यहाँ पर.
CCL ही अपील किए हैं.
CCL अपील किए हैं और आपको कुछ नहीं मिला है.
कुछ नहीं.
क्या बात है भाई? एडमिसिबल अमाउंट भी पेमेंट नहीं करते हैं आप इनको? आप अपीयर कर गए हैं?
हम अपीयर कर रहे हैं. On the time of LA award, your lordship, 15 lakhs has been paid by the CCL, and without any reason they filed the appeal, and I am
आपको मिल गया ना पैसा 15 लाख?
The amount that was
वो
adjudicated
amount-
by collector that we pay.
LA कोर्ट 90 लाख रुपया हमको अलाउ किया है. They are filed the appeal.
तो एग्जीक्यूशन क्यों नहीं फाइल करते हैं?
Lordship, in the meantime they filed the appeal.
स्टे है क्या?
नहीं.
फिर स्टे है?
नहीं.
नहीं है, एग्जीक्यूशन पर केस फाइल करिए, आपने मेंशन करेंगे एग्जीक्यूशन.
Ladyship, for the grace अगर इसको फाइनल हियरिंग में पोस्ट कर देते हैं.
आप एग्जीक्यूशन
Final
केस बिना
disposal.
फाइल किए हैं, फाइनल डिस्पोजल चाहिए. अभी दूसरा दिन करिएगा, अभी छुट्टी का टाइम होने वाला है.
Ladyship, they are hand to mouth.
Return to source.
RTS is what? Return to source. और आप भी वही लिखेंगे, तो हम लोग कैसे पढ़ेंगे और किसको समझेंगे? रिटर्न आंसर लिखा है, ठीक है? शॉर्ट फॉर्म नहीं लिखा.
For grace,
So that-
it was from final disposal.
अरे भाई हम नहीं कर पाएंगे इतना केस. अगर कर पाते तो हम जरूर कर देते. अगला हफ्ता मेंशन
Any date.
डेट हम नहीं कर पाते इतना केस. हम कहाँ मना कर रहे हैं, हम तो सबका केस अलाउ करते हैं मेंशनिंग, लेकिन नहीं इतना कर पाएंगे. अभी नहीं पता है ना, जजमेंट्स भी लिखने का काम पेंडिंग पड़ा रहता है.
जब देखते हैं ladyship तो
थोड़ा हम पर भी दया करिए. चलो.